Today I want to go over an important topic that I get asked about a lot, which is the K-1 fiancé visa. It's a very important topic because people are interested in bringing their future spouse to the United States, have the option of getting married and bringing it in as a spouse as opposed to bringing it as a fiancé. There's pros and cons, positives and negatives to this process and the timelines and the costs and everything associated with it. So I wanted to do an in-depth video for you to break down what the fiancé visa, the K-1 fiancé is and it isn't, so you can make a right decision that's for you. Thanks again for joining me today. I'm going to have a good discussion breaking down the K-1 fiancé visa and what it entails and what it's about. There's a lot of different parts to it. We'll try to cover everything here. If you need more information, just contact my office to schedule a consultation. That's the best way to do it, to match what the situation is with your case. But let's break down where to start. Okay, so typically, most people do a marriage-based green card, which is they get married, they file for a green card, and the spouse eventually comes to the United States. Or if they're already in here, then they just get married, file here, and wait it out until they get the green card if the case is appropriate. But the fiancé visa is a situation where the foreign fiancé, the future spouse, is outside of America. And so they can't just come in here. Many times they are not already here on a student visa or on a work visa. They're outside and they want to come here. The legal way to come to the United States with the intent to get married and file a green card and get a green card is the K-1 fiancé visa. Now, some people come on tourist visas temporarily for fun, maybe to see their boyfriend or girlfriend or significant other, and then after arriving, they decide to get married and apply for a green card. That is okay in most cases, unless you could show, or USCIS, the immigration department in the United States, thinks that you're coming to get married and the tourist visa you used or the student visa that you used was a lie. It was a misrepresentation or fraudulent reason to come to the United States. So as an immigration attorney, I can't recommend people bypass the system of the K-1 fiancé visa with the tourist visa to enter and get married. That's fraud or misrepresentation. It should not be done. But in some cases, it happens pretty frequently. People come in on that tourist visa and then decide, hey, I want to stay and live here and start a life with my spouse. I wasn't expecting it, or else all of a sudden I got pregnant and now we're deciding to stay here because I don't want to travel and fly while I'm pregnant or have the baby overseas, all that kind of stuff. It does happen, and many times, most of the time, it's okay. So let's go back to the situation that's not like that, that not come to the United States. The foreign partner, the future spouse, is outside of America. What do you have to do to start a fiancé visa? Well, first of all, the first rule is this. The U.S. person that's going to get married has to be a U.S. citizen. It cannot be a green card holder. Only a U.S. citizen can give the power of green cards to their foreign fiancé, their future spouse. So that's the first thing. The second thing is the two partners must have met each other physically at least once in the last 2 years. And most people don't have a problem with this. They travel back and forth and see their fiancé. And we could document that with tickets and flights and photos and all this other ways of showing that they really have seen each other physically in the last 2 years, which is a major requirement. Now, in some cases, it's not possible to do that. Some people, less and less, have a religious exception where they can't meet their fiancé until they're actually married. If you could properly document that, which is rare, again, very few religions require this, and USCIS is very strict on this, you could request the waiver of the 2-year meeting requirement. There's another way of waiving it if it's just other hardship that's possible, and that's be very, very extreme hardship. It can't just be for simple stuff that's difficult or flights are too expensive or the like, because they give you 2 years. In 2 years, you got to be able to kind of match it up to see each other. If you can't go to that foreign country, for example, maybe both of you could fly to another country to see each other. So they always say there's other ways to do it. I have gone this way before, and it was an extreme case where the U.S. citizen was so handicapped and had so many medical problems they couldn't even leave their house. And we got doctor's letters to document this. And the fiancé tried to get a tourist visa to come and visit at least once, and they were denied. So we said, listen, the foreign fiancé can't come in. This guy can't even leave his house without being in pain. We have to get the waiver. We got it, but it took a long time. So expect delays to happen if you're doing a waiver case because they just don't give those out easily. So the initial part is that, U.S. citizenship and seeing each other once in the last 2 years. Now, the rest is important too in the sense that you got to document that this is a real relationship. You've had a history of talking together and seeing each other maybe. Just something to show it's not a fake relationship. They also look at the background of both parties, but in this first step, we're going to break down what the steps are. If the U.S. person has serious criminal history or any arrests or convictions, stuff like that, They want to get into that because they don't want the foreign spouse to come here, the future spouse, and be married to somebody that could be potentially, have criminal activity or abusive or like. So that does pop up, and you do need to get into it in the form. So let's talk about the forms and the process that pops up now. That we got the basics out of the way of what you need to start a fiancé visa case. The first thing that you need to do is deal with USCIS, the U.S. Citizenship and Immigration Service. They're the immigration department within the United States that processes these cases when they start. You do that by submitting Form I-129F, I-129F, and that is a lot of biographic information in the form that lets them know you're a couple and what you're trying to do. On that form, it does list which embassy you want to go to. It's usually the home embassy of the foreign fiancé where they want to have the process to go. So you can check that out. But along with that form, you document the relationship. So it's documentation of the trueness of the relationship. There's also evidence that you saw each other once in the last 2 years, evidence of U.S. citizenship status of the U.S. person, that they're a U.S. citizen. And also, this is very important because a lot of people who file the case on their own are not aware of this. You have to file a statement for each party that says you intend to get married in the United States and that you are not married or don't have any issues that prevent you from getting married. So some people might not be divorced yet, so that doesn't allow it. So you have to have that. It's a simple 1 or 2 liner right there, but if you don't do that, they're going to deny the case. And a lot of times that does happen, so be prepared for that. Now, in addition to the things I said, those are the basics. If you had divorce history, you need to submit divorce records to show that you're single at this time. And every case could be different. There's certain arrest history. You want to document that. Some serious cases require a waiver if there's certain abuse type cases that you should consult with an attorney with if you have that. And every case is different. So there may be special documents that are needed in your case that's not typical that I can't really go in here because everything could be so different. But those are the basics of the first step. Step 1 of a fiancé visa, submitting the form I-129F package, not only the form, but the whole package of information to USCIS. Now, this typically would take 6, 7, 8 months. It goes up and down. It's really unreliable. I've seen it go longer. I've seen it go faster. I've had it done in I think it was like 3 weeks once. It was incredible. But I've had it go a year and a half too. Timelines are super inconsistent, so be prepared for that. But let's say you submit that form to USCIS. The form gets approved. You get an approval notice in the mail that says your your I-129F is approved. Now, they have a timeline that is valid for a few months. Now, people get worried because sometimes the embassies aren't open. They're not scheduling an interview in time. COVID-19 happens, everything shuts down. The embassies are flexible and they can increase the deadline of the I-129F approval, the USCIS approval notice, longer and extend it if they want to. So don't be too afraid of that. It's really rare that they wouldn't extend it. It's got to be a serious situation. Once a case is approved by USCIS, they send the case to the Department of State through the National Visa Center. The National Visa Center, or the NVC, typically is a group that handles a lot of paperwork for green card cases that are going through the embassy. However, in the case of a K-1 fiancé visa, they only nominally touch the case and don't really just transfer it. They don't get too much involved with it. You deal directly with the embassy where the interview is going to happen, and that's where documents are submitted. So, okay, we got the first part done, the I-129F package. Now we're starting consular processing. And this is a step for the foreign fiancé to be able to go to the embassy, do an interview so they believe that they're appropriate for a fiancé visa and they have the right background for them to issue the K-1 fiancé stamp in their passport and allow them to fly into the United States. So this is a big part that you got to prepare for. First of all, it can take a few weeks to a few months for the embassy to get the package. It really shouldn't be more than 4 weeks, but who knows, this inconsistent system. When they get it, they will issue a case number that's associated with the case, and they'll notify to get started. But what you should do, once you get the first I-129F package approved, is to go to the website, and you should have probably done this before I'm starting the case, but go to the website of the embassy you're going to, and they usually have a PDF that breaks down how they want their fiancé visa package to look like. Each embassy does it differently. So whenever I know which embassy I'm going to be dealing with, I go to that embassy's website and I check out what the PDF they have for K-1 fiancé visas and what their unique requirements are. And really at the beginning of the case, I refer to that so I know what things I need to prepare for that step. Now, in this part, there's two major things that they're looking at. The background of the foreign person, so they may need police certificates, criminal records, and the like, passports, birth certificates, divorce certificates, a full background check of the person, make sure they're okay, as well as financial aspects to make sure this person is able to support themselves, whether a U.S. fiancé could help them, or maybe sometimes a joint sponsor could help. Now, the sponsorship form that you submit here is Form I-134. It's different from the form for sponsorship you submit once they're in the United States and applying for the green card, form I-864. This is 1-I-3134 is for the embassy. So you have all this paperwork ready. You take it with you to the embassy. And 2 notes before that, there's a form online you have to submit called Form DS-160. Type that in Google, find it. It's on CEAC, the SEAC website, DS-160. It's a lot of biographic information, has to be done right. You don't want to be missing information on there. It could be considered fraud or misrepresentation if you make a major mistake. And this is one of those reasons why I really recommend you have an immigration attorney holding your hand and walking you through this process. But nonetheless, you submit Form DS-160 online. It gives you a receipt once it's submitted. You bring that along with all the civil documents that the embassy asks for and the financial documents, which could include tax returns, pay stub, W-2s, and all the like that you really got to study and do that part. But I can go into detail on that here. And once you do the embassy interview, hopefully they issue the visa stamp soon, and then you can fly into the United States. Now, 2 things I want to note. One, I wanted to add with the documentation you need to bring to the embassy is a medical appointment that you have to schedule to bring with you. The doctor either electronically submits the medical checkup to the embassy directly, or they give you a sealed envelope, and it may include vaccines that you took at that time. And you want to keep this record because later on, when the foreign fiance comes into the United States, you want to provide this to USCIS on the adjustment status application. We'll talk about that in a moment. So they see that this person has a clean bill of health and doesn't have any issues. It's valid for 1 year after entry. Now, there's a big issue and a big importance that people give for the fiancé visa because they think it's faster. And I understand you want your foreign spouse or foreign future spouse or fiancé to come to you sooner. You're in love. Why? You don't want to be separated for how long. You want to get things going. So people do the fiancé visa. The place where the fiancé visa is faster is in this section. When USCIS approves the initial case and sends the case to the embassy for the interview, it typically in a normal timeline, no major concerns and stuff, takes about 1 to 2 months to get that done. There's extreme cases. There's some countries that are harder than others, but typically 1 to 2 months right there. If you did a marriage green card case, the initial portion that USCIS does, which is similar to that I-129F package, once that's approved, the case goes to the National Visa Center, could easily take 2, 3, 4 months easily. So that's where the time savings come in these kind of cases. It's the time it takes for USCIS to send the case to the embassy and get an embassy interview scheduled. For the K1, it's faster. That's a time savings of maybe a month or 2, maybe 2 months, let's say, that you save. Now, if you're in love and you're separated from your loved one, 2 months is a big deal. But as they go to the next step, you'll see why I usually don't recommend the fiancé visa, and I prefer not to. But we'll get that in a second. So a person gets the fiancé visa, they pack their bags, and they come to the United States. Once they're here, they have 90 days to get married. If they don't get married within 90 days, they have to then just do a full marriage green card case in the United States and do everything all over again. We're not going to go into that too much here, but typically everyone just gets married within the 90 days. And once they get married, they file for adjustment of status, Form I-485. So Form I-485 is a request for green card from within the United States. And when that person is pending that case, they could just stay here and wait until eventually, in most cases, they do an in-person interview at the local field office. Not always, sometimes they waive the interview, but it does come up. Now, how long does it take to do the the field office interview, the local interview in the US? It varies. It depends on your local office and how busy they are. They may be understaffed, so it takes longer. There may be a local office somewhere where they don't have much work to do, and it's faster. And that's the inconsistency of the system. There's no exact timeline. But on the bright side, you have your significant other here, you're married, you're living your life here. Sounds good, right? Well, not really, because the foreign fiancé who's now married does not get a work permit, and they're not allowed to travel outside the United States. When we file the application for a green card, normally my clients, we submit a request for a work permit and a request for travel permission so they can leave the United States. But, it takes a long time for that to get approved. It could easily take, 6, 7 months after requesting it for it to be approved, sometimes even longer. And during that time, the foreign fiancé is here all of a sudden at home and unable to work and unable to travel, maybe see their relatives overseas outside the United States. And they're stuck. And what I've seen is it causes a lot of friction and a lot of annoyance in the couples. And that's why typically I say, just get married. And when you get married and get the green card approved through the embassy and you fly in, as soon as you come in, you get the green card in the mail a few weeks later, hopefully, and you can start working and live your life here. But when you enter on the fiancé visa, you still need to apply for a green card, wait, and do an interview before you could really get your life started here. And it's a difficult situation to do. And so that's why I don't usually recommend people do the fiance visa. It does save a month or two to see each other faster. But on the other side, you come here without a work permit, without travel permission. And for many couples, it's a very difficult thing to do and causes a lot of headaches. So that's why it's not usually recommended. 1 out of 10 times we do a fiance visa as opposed to a marriage case. The second issue that pops up that I don't like about the fiance visa is it has all these extra steps that you don't have if you're doing a marriage case. As I mentioned, if you get married and get the visa through the embassy to come here, your green card is issued, that's it. It was 2 steps. The initial filing to prove the relationship is real, then the embassy. But when you do the fiancé visa, you have the initial step, and then you have, which is with USCIS, then you have the embassy step, and then you come into the United States, and then you have to file another green card application, and then most likely do another interview. So all of a sudden, there's 4 steps involved. And with that, more filing fees. Now, the last step, the interview doesn't have a filing fee, but the first 3, each of those steps have a filing fee. So it adds up, and it adds up a lot. And secondly, with regards to fees, if you're handing a lawyer is doing the case, each of those steps have more fees too. So all of a sudden, my legal fees would increase by 20-30% easily for a fiancé visa case, if not more, as opposed to a marriage case. And so I always want to work to the benefit of my clients. I say, well, you might see each other 1 or 2 months sooner, but you're going to pay this much more, and you're not going to have work permits. You have to be at home sitting there doing nothing for all these months and getting frustrated. Why pay me and the government the money? Just use that extra money, buy a plane ticket, and go travel and have a vacation together while the case is pending. Why? Enjoy yourselves. That's what I would have done. So it is what it is. And I just say get married and do that and use that money for your honeymoon and apply for the green card. We could do it like that. Now, what scenarios would somebody say no to that? I've had 2 cases recently where they said, no, we couldn't do that. One was a couple that were in the same-sex relationship. They couldn't get married in most other countries that they could travel to, so they're forced to do a fiancé visa process. Another case was a person who had come to the United States with their family as asylees, and she had fallen in love with her high school classmate, but that person couldn't go back to the home country to get married, and that person couldn't travel either. It was too much of a headache. And what they really wanted, the U.S. person, was that she wanted her family to be at the wedding. So she didn't want to just go to that home country that the family fled from just to get married for the process. And it's not just to get married for the process. They were going to get married anyways, but just get married to avoid the fiancé visa and do the long consular processing route for a marriage case. But the family couldn't go to home country, and they wanted the wedding and the marriage to be all at once, and it might be a religious kind of emotional experience. So they say, you know what, we're just going to do a fiancé visa. So my fiancé comes here, my family could be there when we're having the official marriage, and not just have a ceremony here, but not the civil lawful marriage be in that country. So there's extreme situations that pop up like this that have personal reasons why people do this. But for the most part, people could see each other, get married, have the wedding in some other country, a destination wedding in the home country, wherever it is, and then just do the marriage green card process. So that was an overview of it. You do a USCIS filing, you deal with the embassy, each of them have their own forms. Eventually, you come to the United States, get married within 90 days, and file the green card application with a work permit, travel permission if you like. If you like to do those two, also there's an affidavit of support, Form I-864, and potentially Form I-944, the public charge declaration of self-sufficiency. As I'm recording this, there's controversy of whether we have to submit that or not, but you got to keep an eye out on that, along with a bunch of civil documents and potentially some additional forms of paperwork depending on the details of your case. So that was a full recap of the fiancé visa process. The main parts that people have questions about is the timelines and why I prefer not to do them in most cases. I mentioned and described those. There's a bunch more that we can get into. There's issues what if you separate, or what if this or that. Those really need an in-person private consultation because they're so different and they need such a longer discussion. I'm not sure how many minutes I've talked so far, but as you can see, this was just a simple overview and it took this long. Once we dive into the application, there's more stuff and hours that come. Just seeing what kind of documents you have, joint documents that could show the relationship, this whole thing, then the financial parts of it, then the embassy preparation. If there's any previous immigration history for the foreign person into the United States, we got to dive into that, what you told the embassy beforehand. There's a whole lot of stuff that pop up that we need to discuss. You could always just schedule a consultation with an attorney for help on that. But I hope this information helped. I'm John Khosravi, managing attorney of the JQK Immigration Law Firm, headquartered in Los Angeles, California. But I help people from across the world in America. Most of this stuff, almost all this stuff, is done by sending government mail to the office location. Doesn't make a difference. We could just set up a video consultation and recap everything. Thank you so much for listening. I wish you all the best, and congratulations on getting married. Bye-bye.